Hey everyone, welcome back. Today, we're diving deep into something really relevant, especially for those of you here in the Philippines.
Oh, yeah.
Wills and succession.
Mhm.
It's all about making sure your legacy, is taken care of just the way you want it.
Yeah, it's super interesting how this area of law blends those big life questions with like practical planning.
Right. We're going to be using Wills and Succession, this book by Sempio D, as our guide.
Yeah.
Think of it as like a roadmap through the Philippine legal system, specifically when we're talking about inheritance.
Mm.
So are you ready to kind of unlock the secrets of wills and inheritance Philippine style?
I think so, yeah. Let's decode all those legal details.
Okay, so first things first, what exactly does Philippine law even consider a will?
Well, Article 783 of the new Civil Code defines it pretty clearly.
Yeah.
A will is a legal document where you, as the testator,
Yeah.
you specify how you want your assets to be distributed after, you're gone.
So it's about having that control even when you're not here to manage things personally anymore, right?
Exactly.
But this book keeps using this term strictly personal act when it comes to making a will.
Right.
What does that even mean?
You can't just delegate this task, like, to someone else.
Oh,
No outsourcing your will making.
right.
Article 784 is super clear on this. You have to be the one in charge.
So no ghostwriters allowed, basically.
Yeah, basically.
But what about getting some help along the way? Like, can you get input from someone while making those decisions about who gets what?
So there are some nuances there. Article 785, it says you can't just leave those big decisions up to someone else.
Like who gets what and all that.
Exactly. Those calls are yours.
Mm-hmm.
But Article 786 does offer some flexibility.
Ooh. Okay, so it gets a little more interesting now.
Yeah.
Tell me about that flexibility.
You can actually appoint someone you trust, to deal with distributing certain assets, as long as you've already decided who those assets are going to.
So, like, the general principle is set.
The framework is there. It's like
Yeah.
saying, okay, here are all my books, divide them among these book club members based on, what genre they like.
Okay. Yeah.
You set the rules, they handle the logistics.
Okay. You retain the control, but you can get help with the details.
Exactly.
That makes a lot of sense. So what happens if something in the will isn't totally clear?
Right.
How do courts approach these like tricky interpretation issues?
Well, the law has some guidelines for that.
Mm-hmm.
The biggest priority is actually making sure that will is carried out, making it operative.
Okay.
That's Article 788.
Got it.
If there are small errors or some information is missing, Article 789 allows for corrections.
Okay.
But it has to be based on the will itself or like solid external evidence,
Yeah.
not just, oh, well, he told me one time.
So no relying on gossip.
Yeah,
Has to be real evidence.
exactly.
Okay, now what if you acquire a new property or new assets after making a will?
Yeah.
Are those automatically included?
Not always, no.
Okay.
Article 793 is very specific.
Mm-hmm.
Anything you acquire after that will is only part of the estate if you specifically stated that.
You have to explicitly say it.
Otherwise, it might be subject to a whole different set of inheritance rules.
Oh,
Yeah,
okay.
yeah.
So it's super important to update your will if your assets change. Anything else that can affect a will's validity.
So Article 794, it basically clarifies that unless you say otherwise, it's assumed you want to pass on all your rights.
To that specific property.
Yeah, and Article 795, this emphasizes that the will has to follow the law that was in place when you made it.
Not what changes later on.
Exactly.
Yeah.
No loopholes, no retroactive changes.
Okay, so this is making me wonder, who exactly can create a will in the Philippines?
Mm-hmm.
Is there like an age limit? Do you have to be in perfect health?
So Article 796, it sets this general rule that basically anyone can create a will, unless there's a specific law saying they can't.
Okay.
But there are a couple of conditions.
Conditions.
Yeah, first off, there's an age requirement.
Okay.
You have to be at least 18 years old.
No surprise there.
That's Article 797.
Makes sense.
And then there's the question of sound mind.
Okay.
This is highlighted in Articles 798 and 799.
So what does sound mind actually mean from like a legal standpoint?
It means you understand what a will is,
Yeah.
what property you own,
Okay.
and who your heirs are,
So you're aware of the basics.
Exactly.
Okay.
The good news is the law actually presumes you are of sound mind,
Oh, okay.
unless someone can prove otherwise.
So there's a presumption of sanity.
Yeah, that's Article 800.
So what happens if you create a valid will But then later on, you become incapacitated. Does that affect anything?
Article 801 covers that.
Okay.
As long as you were of sound mind when you made that will, any incapacity that develops later, it doesn't change anything.
Okay.
It's all about that initial state of mind.
That's good. That's reassuring to know.
Huh.
Are all wills created equal? What are the different types of wills recognized here?
The two main types are notarial wills and holographic wills.
Okay, let's get into those.
Okay.
Tell me everything about notarial wills.
All right, so notarial wills are, they're the more formal option.
Okay.
The name kind of gives it away. They involve a notary public.
Okay.
Article 804 and 805. They outline the requirements.
Right.
It has to be written
Okay.
in a language you understand.
So no secret codes.
Yeah.
Okay.
And signed at the end, either by you, the testator,
Okay.
or someone you authorized to sign for you.
Got it.
It also needs to be witnessed and signed by at least 3 other people,
Okay.
credible individuals, the law says, who are present at the signing.
Hold on. Credible witnesses.
Oh, yeah.
What makes a witness credible legally?
That's a great question. Articles 820 and 821, they define it.
Okay.
A credible witness has to be of sound mind,
Okay.
at least 18 years old,
Mm-hmm.
able to read and write, a resident of the Philippines.
Okay.
And they can't have a criminal record that involves, like, falsifying documents or giving false testimony.
So basically someone you'd trust to be honest and accurate in court?
Yeah, that's the gist of it.
Okay, you said it has to be signed on every page.
Every single page.
By both the testator and the witnesses.
Yes, and the pages need to be numbered using letters, not numbers.
Interesting. Why letters?
Article 805 specifies that it might seem a little fussy,
Yeah.
but these rules are there to prevent tampering and make sure the will is authentic.
It's all about doing things properly.
Exactly.
Anything else on notarial wills?
A couple of things.
Okay.
Articles 807 and 808, they outline some specific things for testators who are deaf or blind.
Okay.
It's about making sure they truly understand what's in the will.
Okay.
And there's some flexibility, too.
Mm-hmm.
Article 809 says that minor imperfections won't automatically invalidate the will,
Okay.
as long as it substantially complies with the requirements.
Okay. So some wiggle room, but it's still better to get the basics right.
Yeah, definitely.
What about those holographic wills? You mentioned those. What
Yeah.
makes them different?
Holographic wills are a lot simpler when it comes to formalities.
Okay.
All they need is to be handwritten,
Okay.
completely handwritten, dated, and signed by you.
No witnesses, no notary needed.
That's right. Article 810 lays that out.
Wouldn't that make them easier to forge, though?
Well, that's where the probate process comes in.
Oh,
You'll
yes.
need witnesses who can confirm that's your handwriting.
Got it.
And sometimes you might even need expert testimony.
So there's still a way to authenticate them.
Definitely. Yeah, that's Article 811.
Okay. Any special rules for these holographic wills we should know about?
Yes, a few important ones.
Okay.
Anything you write below your signature,
Mm-hmm.
it needs its own date and signature.
Oh, okay.
That's Article 812.
Got it.
But if you have sections without dates, and the last one, ISS, dated and signed, that actually validates everything before it.
Oh,
That's Article 813.
interesting.
And lastly, any changes or modifications to the will,
Yeah.
those need your full signature too.
So you have to really confirm those changes.
Yeah, Article 814 states that
These are some detailed rules.
they are, yeah.
So let's say you're Filipino living abroad, or maybe a foreigner living here.
Right.
Do the same rules apply?
Now that's where it gets even more interesting.
Okay.
Article 815. It allows Filipinos abroad to create wills based on the laws of where they're living.
Oh, okay.
And for foreigners, Articles 816 and 817 are even more flexible.
What?
They can actually follow the laws of their own country, or where they're residing, or even the laws of the Philippines.
It's a lot of options there.
It's about making sure there's a legal framework.
Yeah, that makes sense, especially if you're, moving around internationally.
Exactly.
Okay, this is a question I'm sure a lot of couples have. What about joint wills? Can you and your partner create one will together?
Here's where Philippine law takes a firm stance.
Okay.
Joint wills are not allowed.
Like, at all?
At all.
Wow.
Whether they're for your benefit or for someone else, Articles 818 and 819 forbid them.
Okay.
Even if you try to create one in a country where it is allowed.
So that's a hard no.
It's a hard no.
Wow. There's a strong emphasis on individual decision-making here in the Philippines.
There is, yeah.
Why is that, do you think?
Well, there are a couple of reasons.
Okay.
Joint wills, they raise concerns about undue influence.
Like one person pressuring the other.
Exactly.
Okay.
It can also just create a lot of confusion if one person dies before the other. Probate can get messy.
Yeah.
And probably most importantly,
Mm.
it kind of clashes with that core right, of a testator to change their mind, to revoke their will whenever they want.
Okay, those are all really good points, yeah.
Yeah.
So separate wills.
That's what wills.
Okay, so we talked about witnesses earlier, but are there any other rules regarding them that we should be aware of?
Yes. Article 823, it outlines something pretty important.
Okay.
Any gifts or inheritance you leave to a witness or to their close family members,
Okay.
those are automatically void,
Oh, wow.
unless there are at least 3 other competent witnesses there.
So no, like bribing your witnesses or anything like that?
No, it's all about preventing conflicts of interest.
Are there any exceptions to this rule?
Just one.
Okay.
If a witness is also a compulsory heir,
Like your child.
exactly, they don't lose their right to their legit time,
Riches.
the legally mandated share of the inheritance.
Okay.
But anything extra, any additional gifts beyond that, those would be void.
Okay. So it's all about keeping things fair, I guess.
Yeah, fairness is key.
Now, what about codicils? How do those fit in?
Think of a codicil as a mini will.
Okay.
It's a separate document that you create after the main will.
Okay.
Article 825 explains this.
Got it.
It basically clarifies, modifies, or adds to that original will.
So it's like an addendum.
Exactly.
Okay.
And Article 826 is clear. It has to be executed just like a regular will.
With all the same formalities and everything.
No formalities.
Okay.
So
yeah.
it's a way to like fine-tune your will without completely restarting.
That's right.
Can a codicil, can it revoke or replace a previous will entirely?
It can, absolutely.
Yeah.
It can either adjust specific parts or completely replace the original instructions.
A fresh start.
Yeah, fresh start.
Got it. Okay. Now, this book mentions this thing called incorporation by reference.
Right.
What is that?
So incorporation by reference,
Yeah?
It's basically a way to include documents that already exist in your will
Okay.
without actually writing them out word for word.
Got it.
This is especially useful for detailed lists, like an inventory of all your assets.
So I can just like attach a separate list.
Not so fast.
Okay.
There are strict rules outlined in Article 827.
Of course.
First, the document has to exist already when you make the will.
So no adding something later on.
Exactly.
It also needs to be super clearly described in the will.
With the number of pages and all that.
Yeah, the number of pages is important.
Okay.
And both you and the witnesses have to sign each page of that document too.
Okay, so there's a process.
There's definitely a process.
That makes sense, though.
It does.
Okay, let's talk about revocation.
Mm-hmm.
What if you change your mind about your will?
Right.
How do you revoke it?
So revocation, this is a crucial part of wills.
Okay.
And Philippine law offers a few ways to do it,
Okay.
each with their own set of rules.
All right, let's explore those different methods of revocation.
Okay.
What are they?
The main ways are by implication, by overt act, and by making a new will or codicil.
Okay, so 3 main ways.
3 main ways.
Let's start with revocation by implication.
Okay.
What does that even mean?
Revocation by implication.
Mm-hmm.
It's called revocation by operation of law.
Okay.
It means that certain events in your life essentially make your will,
Or parts of it.
or parts of it, void.
So it's not you directly doing something.
It's the law stepping in
Yeah.
and saying, hey, because of these changes, this will doesn't reflect your wishes anymore.
What are some examples?
Oh, there are a few.
Okay.
Article 957 says if you sell or donate something that's in your will,
Yeah.
that specific legacy, it becomes void.
Okay.
Similarly, changes in your marital status, like an annulment,
Okay.
those can affect what you leave to a former spouse.
Mm-hmm.
That's Articles 43 and 50 of the Family Code.
Got it.
And if an heir does something considered unworthy, like tries to harm you,
Okay.
they can be disinherited.
Disinherited.
That's Article 1032.
Okay.
Yeah.
There are a lot of nuances to this.
There are.
What about revocation by overt act? That sounds more like a deliberate choice.
It is. Revocation by overt act.
Mm.
It's exactly what it sounds like.
You destroy it.
You physically destroy the will.
Okay.
Burning it, tearing it up.
Very dramatic.
It can be dramatic.
Okay.
Legally, though, the destruction has to be complete.
So you can't just like burn a corner of it?
Exactly. If you only partially burn it,
Yeah.
it might not be revoked.
Okay.
And you have to be of sound mind when you do it.
Okay.
That intention to revoke is key.
No accidental bonfire.
No accidental bonfires.
And if you destroy the envelope, but not the will itself,
That doesn't count.
okay.
It's all about the document itself.
The physical piece of paper.
Exactly.
Okay, what about that third way, revocation by creating a new will or a codicil?
Right.
What happens there?
That's the most, I guess, straightforward way.
Okay.
If your new will says it revokes the old one,
Yeah.
or if the new instructions completely contradict the old ones, the old will is considered revoked.
So a new will basically just overrides,
Yeah,
makes the old one obsolete.
it does.
That's Articles 830 and 831.
Right.
Okay, what happens if the second will turns out to be invalid for some reason?
Oh, that's an interesting one.
Yeah.
Article 832 has an answer.
Okay.
Even if that second will isn't valid,
Yeah.
it can still revoke the first one.
Oh, wow.
The act of revoking is seen as its own thing.
Okay.
But there's a catch. If the revocation was based on something false,
Okay.
like you thought an heir was dead but they weren't,
Mm.
then it's considered void.
So the intention behind the revocation matters.
It does, yeah.
That's Article 833.
Right.
Okay, is there anything else we should know about this whole revocation process?
Yes, actually, there's this concept called the doctrine of conditional revocation,
Okay.
or dependent relative revocation.
Ooh, that sounds interesting. What is that?
So imagine this. You make a will. Then you create a second one to replace it.
Yeah.
And you destroy the first will.
Okay.
But then that second will turns out to be invalid.
Okay.
Was the first one actually revoked?
That's a tough question.
It is.
What does the law say?
There's a case, De Molo versus Molo. It basically says that in those cases, destroying that first will depended on the second one being valid.
So because the second one wasn't,
Because the second one wasn't.
it didn't actually revoke the first one.
Exactly. The first one was revived.
Wow, that's interesting.
Yeah,
It's like a safety net.
it is.
Okay, so are there any other times when a will might be revived?
Yes.
Right.
Article 837 clarifies those rules.
Okay.
If the second will explicitly revokes the first one
Yeah.
and then gets revoked itself, the
Yeah.
first one stays revoked.
Okay.
But if the second will only impliedly revoke the first one.
Like by having conflicting stuff in it?
Exactly.
Okay.
Revoking that second one actually brings the first one back.
Wow, it's like a legal dance back and forth.
It is.
Okay, one last question on revocation.
Mm-hmm.
If you acknowledge like an illegitimate child in your will,
Yeah.
and then you revoke the will,
Right.
does the acknowledgement still stand?
It does.
Ah.
Article 834 says that even if you revoke the will, acknowledging that child is a separate thing.
Right.
It remains valid.
So you might change your mind about other parts of the will, but that acknowledgement is still there.
It stays.
Okay, that's important to know.
Yeah.
So now let's move on to probate.
Okay.
What happens in that stage?
Probate is the process of, it's the legal process of making sure a will is valid
Okay.
and officially recognizing it in court.
So it's like a will's official stamp of approval.
Yeah, basically.
Okay, so what actually happens?
The court examines the will
Okay.
to see if it meets all the
In
requirements.
terms of format and all that?
Exactly how it was executed.
Okay.
They also look at whether you were of sound mind
Okay.
and acting freely when you made it.
So making sure there was no coercion.
No coercion, no fraud.
Okay, so are there different types of probate?
There are.
Okay.
We have antemortem probate, which is when you're still alive,
Oh, wow.
and then postmortem probate.
Which is after you die. Okay, so anti-mortem probate.
Yeah.
Why would someone choose to do that while they're still alive?
It's about peace of mind, you know.
Okay.
It reduces the chances of someone challenging the will later on.
Because it's already been checked out.
Exactly. It's a court-certified confirmation that it's valid.
So it's like a proactive thing.
Being proactive.
Okay.
Yeah.
Are there ever times when a will might be rejected during probate?
Yes.
Okay.
Article 839, it lists 6 reasons why it might be disallowed.
Okay.
Things like not following the formalities,
Okay.
not having testamentary capacity.
So not being of sound mind.
Right. Being
Okay.
forced or unduly influenced,
Okay.
or having your signature procured by fraud.
So like someone forging your signature.
Exactly.
Okay.
Or just a mistake in how it was made.
So there are a lot of checks and balances.
There are.
Okay.
Yeah.
Okay, so let's talk about one of the core parts of a will. The institution of an heir. What does that even mean?
The institution of an heir. It's the heart of the will.
Okay.
You name the people who will inherit your property
Okay.
and take on any rights or obligations that can be passed on.
Got it.
Article 840 explains it.
So this is where you make those big decisions about who gets what.
It is.
Are there rules for how you name heirs?
Absolutely.
Okay.
Article 843 says you have to use their full names, their surnames.
Okay.
And if there's any chance of confusion,
Yeah.
like maybe 2 people have the same name,
Okay.
you have to include extra details to be clear.
So there's no mix-up.
Exactly.
Okay, what if you accidentally leave out an heir's name?
If it's clear who you meant,
Yeah.
based on what's in the will,
Okay.
it can still be valid.
So your intention is what matters.
Intention is key.
Okay.
Yeah, Article 843.
What if you don't say the exact percentage each heir should get?
Right. Article 846 has a default rule
Okay.
if you don't specify shares.
Mm.
It's divided equally.
Okay.
But this doesn't apply to the legit which is the legally mandated share for certain heirs.
Okay, we'll get into that later.
We'll get into that.
So equal division unless you say otherwise.
That's right.
Got it. What if you want to leave something to, like, a group of people, like my children or my siblings?
Articles 847 and 848 offer some guidance on that.
Okay.
If you name them collectively, like the children of John, they inherit individually, unless you explicitly state otherwise.
Okay.
And if you name your siblings, they inherit equally, whether they're full or half siblings.
Okay, so no favoritism for full siblings over half siblings.
Exactly.
The law really tries to make things fair and clear.
It does.
Can you give an example of how these inheritance rules play out?
Sure.
Like real life situation?
Let's say someone has an estate worth $1,000,000.
Okay.
And they want to leave it to their son and two friends.
Okay.
In that case, each person would get
a third,
333,333.33.
Okay, that's easy.
Yeah, pretty straightforward.
What if they want to leave something to someone and their children?
Oh, that's covered in Article 849.
Oh.
In that case, they all inherit at the same time, not one after the other.
Got it.
So if they had 100,000 pesos to leave to Peter and Peter's two kids, each person gets 33,333.33.
Okay.
Simultaneously.
They all benefit equally and concurrently.
Exactly.
Okay, that makes sense. What happens if you give a reason for the inheritance in the will?
Right.
And it turns out that reason isn't true.
Okay, so Article 850 addresses that.
Okay.
If the stated reason is false,
Yeah.
it's essentially ignored.
Okay.
Unless the will makes it clear that you wouldn't have given the inheritance if you'd known the truth.
Okay.
So, for example, if you left money to your student, Maria, because you thought she got a perfect score, she didn't,
right,
the inheritance would still be valid.
So it's about your intention, not necessarily the accuracy of the reason. So it's about your intention, not necessarily the accuracy of the reason. Okay, now what if the person making the will, what if they only specify heirs for part of their estate? What happens to the rest?
Article 851 has that covered.
Okay.
If you only name heirs for a portion, the remaining part is subject to intestate succession.
Which basically means the law steps in.
Yeah.
Okay.
To figure out who inherits based on family relationships.
Okay, so that makes sure nothing is just left unclaimed.
It does.
Got it. Now, I've been seeing this term preterition in the book. What is preterition and why is it such a big deal here?
Preterition is a legal term.
Okay.
It means you completely omitted a compulsory heir in the direct line from your will.
Oh, okay.
This is a serious issue because it can actually void how you've named your heirs.
Wow. Okay, so it can really shake things up.
It can.
Why is it taken so seriously?
Philippine law is very protective of those closest to you.
Those compulsory heirs.
Exactly.
Right.
Preterition is seen as a sign that you might have overlooked someone.
Or there was a strained relationship.
It could be.
Okay, so it's like a safeguard against disinheriting close family.
Yeah, it's a safeguard.
Yeah.
Whether it was intentional or not.
Does preterition affect the whole will or just parts of it?
Article 854 clarifies that.
Okay.
While it voids the overall inheritance plan,
Yeah.
specific gifts, what we call legacies and devises, can still be valid.
Okay.
As long as they don't mess with the omitted heir's legitime.
Legitime, which is...
The legally protected share.
Okay, yeah.
Yeah.
So even if the main plan gets disrupted, specific gifts might still be okay?
Exactly.
Okay, can you give me an example of how preterition might happen?
Sure. Let's say someone has two children, Anna and Ben.
Okay.
But their will only names Anna as their heir.
Okay.
This is considered preterition of Ben.
Because he's completely left out.
He's omitted.
Okay.
So Anna being the sole heir, that would be annulled.
Okay.
Instead, the estate would be divided according to intestate succession rules,
Okay.
which would give Ben his share.
Okay, so that's how preterition protects those compulsory heirs.
It does.
Got it. What if that heir who was omitted dies before the person making the will?
That's a good question. The second part of Article 854 addresses that.
Okay.
If the omitted heir dies before you,
Yeah.
your will's plan for inheritance becomes valid again.
Okay.
But then representation comes into play,
Okay.
which means that heirs' descendants can claim their share.
Wow, the law really thinks of everything.
It tries to.
Okay, so can you explain representation a bit more?
So representation,
Mm-hmm.
it's this mechanism that allows the descendants of a deceased heir to inherit in their place.
Okay.
It mainly applies to inheritance without a will,
Okay.
and in some cases of
Oh,
preterition.
like what we just talked about.
Exactly. But make sure a whole family line isn't cut off.
That's the idea.
Okay,
Yeah.
can you give me an example of how representation works?
Sure, let's say Tom has a son, David, who has a daughter, Emily. If David dies before Tom.
And Tom dies without a will.
Okay.
Emily would inherit David's share
Okay.
through representation.
So she stands in for her father, basically.
Yeah.
Okay, that makes sense. Are there any limits to representation?
Yes, a few
Yeah.
important ones.
Okay.
It usually only applies to direct descendants,
So not siblings.
not siblings, no.
Okay.
And whoever is representing the deceased heir,
Yeah.
they have to have been conceived when the inheritance starts?
Okay, so there are specific rules about who can represent who.
There are.
Okay, now let's move on to another interesting concept. Substitution.
Okay.
What is substitution and how does that work?
Substitution.
Mhm.
It's basically a way to name backup heirs.
Backup heirs,
Yeah.
in case the primary heir can't or won't inherit.
So it's like having a plan B.
It is a plan B.
Okay.
It's like saying, if this person can't inherit, then this other person steps in.
Okay, I like it. What are the different types of substitution?
There are a few, including simple, brief, reciprocal, and compendious.
But the one that's really relevant here in the Philippines is fidei commissary substitution.
Fidei commissary substitution.
Yeah.
That sounds a little complicated.
It is a bit intricate,
Okay.
but it's fascinating.
Okay, can you break it down for us?
Imagine a grandfather wants to leave some property to his son,
Okay.
but he also wants to ensure it eventually goes to his grandson. Fidei commissary substitution makes that happen.
So it's like a two-stage inheritance plan?
It is.
Okay, so how does that work legally?
Article 863 outlines the requirements.
Okay.
First, the substitution has to be in the will,
So clearly stated.
clearly stated.
Okay.
And the second heir can't be more than one degree away from the first
In terms of relationship.
in terms of relationship. And they both have to be alive,
Or at least conceived.
or at least conceived, yes,
Okay.
when you pass away.
So it's a formal arrangement, not just a casual wish.
It's formal, yeah.
What happens to the property in the meantime? Does the son have full control?
Not completely, no. Okay.
He inherits it, but with limits.
So he's like a caretaker.
He's a temporary caretaker.
Okay.
He can't sell it or get rid of it,
Okay.
but he is responsible for maintaining it.
Got it.
And when he passes away,
Yeah.
it automatically goes to the grandson. The son is called the fiduciary,
Okay.
and the grandson is the fidei commissary.
Okay, so the son's like a steward, making sure it gets to where it's supposed to go.
That's the idea.
Okay. Are there any other rules related to this kind of substitution?
Yes, Article 865 clarifies that the fiduciary can be paid back for any legitimate expenses
Okay.
that he incurs managing the property.
Okay.
And Article 866 emphasizes that the grandson actually inherits directly from the grandfather,
Oh, interesting.
even if he dies before the son.
So his right to the property is already established.
It is.
Okay. What happens if this fidei commissary substitution is invalid?
Article 868 provides a solution.
Okay.
Even if the substitution can't happen.
The inheritance to the son is still valid.
Okay.
That problematic clause is just ignored.
So the will still has some effect.
It does.
Okay, that makes sense. Now let's shift gears and talk about dispositions with conditions or terms.
Okay.
How are those different from a regular inheritance?
Dispositions with conditions or terms, they let you add requirements or timelines.
Okay.
It's like saying, you inherit this, but only if you do this.
Okay.
Or you inherit this, but not until this happens.
So it's about adding those extra stipulations.
It is, yeah.
Okay. Are there any limits on what kind of conditions or terms you can use?
A big one.
Okay.
You can't put conditions or terms on the legit time,
Oh, yes.
the legally mandated share that certain heirs have to get.
Okay.
That's Article 872.
Okay.
These only apply to the free portion,
Okay.
the part you can freely decide about.
So you can't use them to mess with those protected shares.
Exactly.
Okay. What are the different types of dispositions with conditions or terms?
There are the three main types: dispositions with a condition,
Okay.
dispositions with a term,
Okay.
and modal institutions.
All right, let's take those one by one.
Okay.
What's a disposition with a condition?
So with a condition, you're attaching a requirement the heir has to meet
Okay.
to inherit.
To inherit.
Yeah.
Okay.
For example, they have to graduate college
Or get married.
or get married
Okay.
before they get their inheritance.
So it's a way to encourage certain actions.
It can be, yeah.
Okay.
Are there limits on what kind of conditions you can set?
I would assume so, yeah.
Absolutely.
Okay.
Article 873 says any conditions that are impossible, illegal, or immoral,
Okay.
those are void,
Okay.
but the inheritance itself is still good. The condition is just ignored.
So you can't be like, you have to climb Mount Everest.
No Mount Everest.
Do something illegal.
No illegal activities.
Okay, what about conditions related to marriage?
Article 874 specifically addresses that.
Okay.
A condition that totally forbids marriage.
Okay.
That's void. It's against public policy.
Okay.
But there are some exceptions.
Exception.
Yeah. Okay.
What are those?
If your deceased spouse put a condition in their will
Okay.
preventing you from remarrying,
Okay.
or if their parents or descendants impose that condition,
Mm-hmm.
it can be valid.
So respecting the deceased's wishes, but still...
But only for the free portion.
Okay.
You still get your legit time.
So there's that balance there.
There is.
What about dispositions with a term? How do those work?
With a term,
Mm-hmm.
it's a time frame, not a condition.
Okay.
It's about when the inheritance happens, not if.
Okay.
So you could say someone inherits when they reach a certain age.
Or after a certain amount of time has passed.
Exactly.
Okay, so it's about timing, not so much about fulfilling a requirement.
That's right.
Okay, so how is that different from a condition?
The key difference is certainty.
Okay.
A term is guaranteed to happen,
Okay.
while a condition, maybe not.
So with a term, the heir gets their rights right away,
They do. That's Article 878.
even if they don't actually get it until later.
It's just a matter of waiting.
Okay.
Yeah.
What are the different types of terms you can set?
There are three main types.
Okay.
Suspensive, resolutory, and ex die diem.
Okay, what are those?
So a suspensive term,
Mm-hmm.
it postpones the inheritance
Okay.
until something specific happens.
Like reaching a certain age.
Like reaching a certain
Yeah,
age.
yeah.
A resolutory term sets an end date,
Okay.
after which it might go to someone else,
Got it.
and ex die diem.
Okay.
That means it lasts for a fixed period.
Okay, so a beginning date and an end date?
Exactly.
Okay, so there's a lot of variation there.
There is.
Okay, now what about that third type you mentioned? Modal institutions. How do those work?
A modal institution
Mm-hmm.
is when you attach a specific purpose or obligation to the inheritance.
Oh, okay.
It's like saying, you can inherit this, but you have to use it for this.
So it's not just giving them the property, it's making sure they use it in a specific way.
Exactly.
Yeah. Okay,
No.
can you give us an example?
Sure. A classic one is leaving money for your funeral expenses.
Oh, okay.
The heir can claim it right away,
Okay.
but they're obligated to use it for that purpose.
So there's a responsibility tied to it?
There is.
Okay, how does that differ from a disposition with a condition?
With a modal institution,
Mm-hmm.
the heir can take the inheritance immediately,
Okay.
as long as they guarantee they'll follow through on your wishes.
Okay.
With a condition, they don't get it until they meet that condition.
So a little more flexible with the modal institution?
Yeah, a bit more flexible.
Okay, that makes sense. Now let's talk about legistime.
Go.
This seems like a really important concept in the Philippines.
It is.
What is it exactly, and why is it so important?
The legit time is a legally mandated portion of your estate
Okay.
that specific heirs, compulsory heirs, are entitled to. It protects the rights of your closest family members.
So it's not just up to the person making the will.
No, there are legal limits
Okay.
to ensure fairness.
Okay, so who are those compulsory heirs? How is their share of the legit time determined?
The primary ones are your legitimate children and their descendants.
Yeah.
If you don't have descendants, then it's your parents and descendants.
Okay.
And your spouse is always a compulsory heir.
Okay, so spouse, children, parents.
The closest family.
Got it. What about children born outside of marriage? Do they have any rights?
They do.
Okay.
They're considered compulsory heirs as well,
Okay.
but their share of the legit time is calculated differently.
Okay, so there's a distinction there.
There is.
Okay, how are the shares of the legit time calculated?
It depends on who the surviving heirs are
Okay.
and their relationship to the deceased.
Okay.
But here are some basic principles.
Okay, go ahead.
The legitipend for legitimate children is half of the estate,
Yeah, okay.
to be divided equal. So if there are two legitimate children,
Yeah.
they each get a quarter
Okay, so each gets a quarter of the estate.
as their legit time.
Got it. What if there's just one?
They still get half.
Half. Yeah.
The other half is the free portion,
Okay.
which you can decide about.
Okay, and the surviving spouse's share.
That depends.
Okay.
If there's one legitimate child,
Yeah.
the spouse gets a quarter,
Okay.
and the child gets the half.
So the child's share takes priority.
It does.
Okay, what if there are multiple legitimate children?
They still get their half,
Okay, divided equally.
divided equally.
Okay.
The spouse gets a share equal to one of the children.
So the spouse is treated like another child, essentially.
For calculation purposes.
Okay.
Yeah.
What if there are both legitimate and illegitimate children?
Things get a bit more complex there.
Okay.
The legitimate children still get their half.
Okay.
The spouse gets a share equal to one legitimate child. And the illegitimate children get a share that's calculated based on what a legitimate child would receive.
Okay, so it's all calculated in relation to that.
Yeah, it's relative.
Okay, any other scenarios we should be aware of?
If there are no descendants,
Okay.
but the deceased has legitimate parents and a spouse,
Okay.
the parents get half.
Okay.
The spouse gets a quarter.
Got it.
And of course, if it's just the spouse,
Yeah.
they inherit everything.
Okay, it's interesting to see how the law, ranks things.
It's a system of priorities.
Okay, so can you ever reduce or get rid of the legitime?
Not usually.
Okay.
Article 904 says you can't exclude those compulsory heirs from their legitime,
Okay.
except in very specific situations defined by law.
Okay.
You can't put any conditions or restrictions on it either.
So it really is a protected share, making sure those closest are taken care of.
It is.
We'll get into those situations where disinheritance is allowed later. But first, I want to ask about something that I saw in this book that really caught my eye. Reserve a troncal.
Okay.
What is it, and how does it work?
Reserve a troncal.
Yeah.
It's a very specific concept in Philippine law.
Okay.
It's all about keeping inherited property within a certain family line.
Okay.
It prevents property that came from one side of the family
Yeah.
from going to people outside of that line.
Can you give me an example? It sounds a little confusing.
Sure.
Okay.
Imagine a mother gives a piece of land to her daughter as a gift.
Okay.
Then the daughter dies, no children,
Okay.
and leaves that land to her father in her will.
Oh.
Reserve a troncal would then step in
Okay.
to make sure that when the father dies,
Yeah.
that land goes back to the mother's side of the family,
Oh.
where it came from originally.
So it's like a legal boomerang,
It is kind of
bringing the property back to its origin?
back to its roots.
Okay, so how does that actually work in practice?
Article 891 explains it.
Okay.
If an ascendant,
Like a parent.
like a parent, grandparent,
Okay.
inherits property from their descendant
Okay.
that was originally a gift from another ascendant or sibling,
Okay.
they have to reserve that property
Okay.
for certain relatives on the original daughter's side.
So there are rules about who it can go to.
There are rules.
Okay, who are the people entitled to this reserve property?
They're relatives within the third degree of kinship.
Third degree.
Yeah.
Okay.
From the person who first got the property.
Okay.
Legally, they're called the propositus.
Okay, so in our example, it'd be the mother's relatives.
Right.
Okay.
Within the third degree from the daughter.
So siblings, nieces, nephews, grandparents, great-grandparents, all on the mother's side.
That's right.
Okay, how is the property divided among them?
Direct line relatives come first.
Okay.
So a grandparent on the mother's side would have a stronger claim than a half-sibling of the daughter.
Okay, and what if there are multiple relatives in the same degree?
The closer ones come first.
Okay, so it's all based on how closely related they are to that original recipient.
Exactly.
Okay, what if there are no eligible relatives within the third degree?
Then reserve a troncal doesn't apply.
Okay.
The person who has the property can do what they want with it.
So it's a conditional reservation.
It is.
What else should we know about reserve a troncal?
So those eligible relatives, they're called reservees.
Okay.
They inherit directly from the propositus,
Okay.
not from the person who was holding it most recently, the reservista.
So they're like conditional heirs.
Yeah, conditional heirs of the propositus.
Okay.
Yeah.
It's a pretty nuanced system.
It is, definitely.
What are some of the broader implications of this reserve a troncal?
Reserve a troncal is unique to Philippine law.
Okay.
It shows a strong emphasis on family and ancestry.
Okay.
It's a way to keep property within a branch of the family.
Even as it moves through generations.
Exactly. It prevents it from leaving that specific line.
It's like a protection against diluting the family's heritage.
You could see it that way.
This has been so helpful.
I'm glad.
Now let's go back to disinheritance.
Okay.
Earlier we said you can't disinherit someone from their legitimate.
Right.
except in specific situations.
Right.
Can you talk more about those grounds for disinheritance?
Disinheritance is serious business.
Okay.
It can only be done for specific reasons outlined in the law.
Okay.
It means cutting off an heir's right to inherit completely.
Including their legitimate?
Everything.
Okay, so it's not just reducing their share, it's completely excluding them.
It's a complete exclusion.
Okay, so what are those grounds, and are they the same for all heirs?
They depend on the relationship between the testator and the heir.
Okay.
Article 919 lists the grounds for disinheriting children
Okay.
and descendants.
Okay, go ahead.
This can happen if they try to kill you, the testator,
Okay.
or your spouse, or other family members.
Yeah.
They can also be disinherited for falsely accusing you of a serious crime,
Okay.
committing adultery with your spouse, refusing to support you, mistreating you,
Okay.
leading a dishonorable life,
Okay.
or being convicted of a crime that results in civil interdiction,
Which is?
the loss of certain civil rights.
Okay, so these are serious offenses.
Very serious.
What about disinheriting your parents?
Article 920 lays out those grounds.
Okay.
They can be disinherited if they abandon their children
Okay.
or lead them towards an immoral life,
Okay.
trying to kill the other parent,
Okay.
losing parental authority,
Okay.
refusing to support their children,
Mm-hmm.
or improperly influencing you to make or change your will.
So again, things that represent a real breach of trust.
A serious breakdown.
Okay, and disinheriting your spouse.
Article 921 covers that.
Okay.
The grounds are similar to those for children and parents.
Okay.
Things like trying to kill you,
Mhm.
making false accusations,
Okay.
behaving in a way that leads to legal separation,
Okay.
losing parental authority,
Okay.
refusing to support their children, or
So in each case, it points to like serious misconduct or a breakdown of the relationship.
it does, yeah.
Can you give me a real life example of how disinheritance might happen?
Let's say a testator has 3 children,
Okay.
and one of them was convicted of trying to kill them.
Okay.
That child could be disinherited,
Okay.
which means they lose all inheritance rights.
Including their legit time.
Everything.
Okay, would the other 2 children then just inherit the whole estate?
Not exactly.
Okay.
The disinherited child's legit time.
Yeah.
It's redistributed among the other compulsory heirs.
Okay.
So the other 2 children would get their own legit times,
Mhm.
plus equal shares of the disinherited child's portion.
Okay, so it's redistributed, not just like someone benefits.
It's reallocated.
Okay, that makes sense. Are there any times when disinheritance might be overturned?
Yes.
Okay.
If you don't give a valid legal reason,
Okay.
or if the reason you give isn't true,
Okay.
it won't be upheld.
Okay.
Also, if you reconcile with the person you disinherited, the disinheritance is revoked.
So you can change your mind.
You can.
Okay, that's Article 922.
Right.
What if the disinherited heir has children?
Article 923 covers that their children can inherit their parents' legit time,
Oh, okay.
even though the parent is excluded.
So the parent is cut off, but the children still have rights?
That's right.
Okay, now let's move on to legacies and devises.
Okay.
What's the difference between those?
Legacies and devises.
Mm-hmm.
There's specific gifts of property in your will.
Okay.
A legacy is for personal property.
Okay, so like money, jewelry, things like that.
Exactly. Things like money, jewelry, cars.
Okay.
A devise is for real estate,
Okay.
like land or buildings.
Okay, so it's about what kind of property it is.
It's a categorization.
Okay, are there rules about who's responsible for carrying out those gifts?
Yes. Article 952 explains that
Okay.
if you don't name a specific person,
Mm-hmm.
it falls on the person in charge of the inheritance.
Or the executor.
The executive.
Okay.
Yep,
Okay, so there's a clear order there.
there is.
Okay, what are the different types of legacies and devises?
You can make specific and determinate legacies or devises
Okay.
where you clearly say what item is being given.
Okay, so like my antique watch.
Exactly. Or the house I own on Main Street.
Okay, so very specific.
Very specific.
Okay.
And the ownership transfers immediately when you die,
Okay.
including any benefits that come with that property.
Like fruit from trees or income that hasn't been collected yet.
Exactly. Article 948 covers that.
Okay, what about gifts that are more general?
You can also make generic legacies or devises
Okay.
where you define the gift by category,
Okay.
not as a specific item.
So like a car or something.
Right, like a car or a sum of 50,000 pesos.
Okay.
In those cases, the person handling the estate has to provide something that fits,
Okay.
even if your estate doesn't actually have that
Then
thing.
they have to fulfill your intention, even if they have to go out and get something.
Okay.
Okay, what are some other kinds of legacies or devises you can make?
You can have alternative legacies or devises
Okay.
where you give the heir a choice between a couple options.
Okay.
Article 940 lays out the rules for that, including who gets to choose, and the fact that once they choose, that's it.
So you give them some flexibility, but within a set of choices you've already made.
Exactly.
Okay, are there ever situations where legacies or devises might not be valid?
Yes, Article 957 has a few.
Okay, go ahead.
If you change the item significantly after putting it in the will,
Okay.
or if you sell it, or if it's totally lost or destroyed, then it's void.
Okay, so that prevents issues later on.
Right.
What if there's a mistake in the will about the property?
As long as it's clear what property you meant.
Okay.
Small errors in the name or description won't invalidate it.
Okay.
Article 958 says that.
So it's more about the intention than being perfectly accurate with the words.
Exactly. The intent is what matters.
Okay. Are there any special rules for legacies or devises that are left to relatives?
Yes, Article 959 limits those.
Huh.
They're restricted to relatives within the 5th degree of kinship.
Fifth degree.
Yeah.
Okay.
And closer relatives come before more distant ones.
So a grandchild would inherit before a cousin, for instance.
That's right.
So again, the law considers how close the blood ties are.
It's a recurring theme.
Okay, this has been really helpful, so let's move on to intestate succession.
Okay.
What is that, and when does it apply?
Intestate succession kicks in when someone dies without a valid will.
Okay.
It's basically the law's way of figuring out how to distribute their things.
So it's like the default plan?
It is,
Okay.
based on family ties.
So it makes sure those assets don't just end up in some legal limbo.
Exactly. It provides a structure.
Okay, so does intestate succession follow the same rules as if there was a will?
Mostly, yes.
Okay.
Article 124 says the rules about who can inherit apply in both situations.
Okay.
But there are rules that are specific to those intestate cases.
Okay, so there's like a hierarchy of who inherits if there's no will?
There is, yeah.
Okay, what is that hierarchy?
First in line are direct descendants.
So children and their children.
Right, legitimate children and their offspring.
Okay.
If there aren't any, then it's direct descendants.
Parents, grandparents.
Exactly.
So the closest family line comes first.
It does.
What about other relatives like siblings, aunts, uncles, cousins, all that?
Those are collateral relatives.
Okay.
They come in if there are no direct descendants or ascendants.
Okay.
And again, closer relatives inherit before the more distant ones.
So siblings before cousins. Like a family tree puzzle.
Can be, yeah.
Okay. What about children born outside of marriage? Where do they fit in?
They have rights,
Okay.
but their share depends on who else is there.
Okay.
They can inherit alongside legitimate children or ascendants,
Okay.
but Articles 983 and 991 lay out how to calculate their share.
Okay, so their rights are recognized, but the calculations are different.
They are, yeah.
What about the surviving spouse? What rights do they have in these cases?
The spouse's share depends on who else is alive.
Okay.
Articles 995 to 1000 get into the specifics.
Okay.
If they're the only heir, they inherit everything.
Okay.
But if there are children, parents, or children born outside of marriage,
Mm-hmm.
their share gets smaller.
So their share is flexible depending on the family structure.
It is.
What if there are no heirs at all within, like, a certain degree of relationship?
Article 1013 has that covered.
Okay.
If there are no heirs within the 5th degree,
Okay.
the entire estate goes to the government.
The government.
Yeah, to be used for public schools and charities.
Okay, so there's a backup plan.
Always a backup.
So we talked about representation earlier
Mm-hmm.
in the context of preterition.
Right.
Can you explain how it works with intestate succession?
So with representation,
Yeah.
if an heir has already passed away,
Okay.
their descendants can inherit for them.
So they're children, basically.
Yeah, or grandchildren.
Okay.
It keeps a family line from being totally left out.
Okay, so can you give an example of that, like a no-will situation?
Let's say someone dies without a will.
Oh.
They have spouse and 2 children.
Okay.
But one of the children died earlier
Okay.
and had 3 kids of their own.
Okay.
The surviving child would get their share, of course.
Yeah.
And the 3 grandchildren would represent their deceased parent.
And collectively inherit that share.
Exactly.
Okay, so they're stepping into their parents' shoes, basically.
They are.
Okay, are there any rules about how that works?
Yes, Articles 972 to 975 cover those.
Okay.
Usually it only applies to direct descendants,
Okay.
not siblings.
Okay.
And whoever is representing the deceased heir
Yeah.
has to have been conceived already when the inheritance starts.
Okay, so specific requirements there.
Yeah, definitely.
Okay, and when that happens, how is the inheritance actually divided?
It's divided per stirps,
Okay.
which means by branch or group.
Okay.
That's Article 974.
Okay.
So those 3 grandchildren would each get a third of their parents' share.
Not a third of the whole estate.
Oh, the whole estate, no.
Okay, that makes sense.
Yeah.
What if someone gives up their inheritance? Can their children still represent them?
That's an interesting one.
Yeah.
Article 976 says, yes, you can represent someone who gave up their inheritance.
Okay.
But Article 977 says if you give up yours, no one can represent you.
So you can stand in for someone else, but no one can stand in for you.
That's right.
Okay. What about children born outside of marriage? Can they be involved in representation?
This is where things get a bit tricky.
Okay.
Article 992 says they can't inherit from their father's legitimate family in an intestate situation,
Okay.
and vice versa.
So the rules of legitimacy affect things here.
They do.
Okay, so those rules of legitimacy impact representation in these cases.
They do, yeah.
This is so detailed.
It is.
So now let's talk about accepting and rejecting an inheritance. What does that involve, and what are the consequences of each choice?
Accepting an inheritance means you formally agree to take it.
Okay.
The assets and any obligations that come with it.
Okay.
Rejecting it is called repudiation.
Okay.
And that means formally saying no.
So you have a choice.
You do.
Okay, what if you don't do anything? You don't accept or reject.
Article 1057 sets a deadline.
Okay.
Heirs have 30 days after the court issues the order to divide the estate
Okay.
to make a decision.
Okay.
If they don't, they're considered to have accepted it.
So silence is agreement.
In this case, yes.
Okay. What are the rules for how you accept or reject?
Article 2041 says it has to be completely voluntary.
Okay.
No pressure.
So no one can force you to accept or reject.
Exactly.
Okay, what about minors or people who can't make decisions for themselves?
Articles 232 and 233 cover that.
Okay.
Basically, their legal representative needs to act for them.
So like a parent?
Usually a parent, yeah.
Okay.
And they need court permission to reject.
So there are extra protections there.
There are.
Okay, what about inheritances that are left to, like, charity or to poor people? Who decides there?
For the poor, Article 1044 says it's the person the testator named to handle the distribution.
Okay.
And for corporations, Article 1045 says their legal representative can accept,
Okay.
but needs court approval to reject.
Okay, so it's interesting how the law thinks of these different situations.
It does.
What if an heir rejects their inheritance, but their creditors are worried about getting paid?
Article 1052 has a solution.
Okay.
Creditors can ask the court to accept on the heir's behalf,
Okay.
but only up to the amount they're owed.
So they can't profit off of it?
No. Any leftover money would go to the other heirs.
Okay, so there's a balance there.
There is.
Okay. This is all incredibly helpful.
Good, I'm glad.
So now let's talk about collation.
Okay.
What is that?
Collation is about accounting for gifts or advancements the deceased person made while they were alive. It's about ensuring the division is fair to all the compulsory heirs.
So it's about taking those previous gifts into account. Why is collation so important?
Imagine a parent gives one of their kids a big chunk of money as a gift.
Okay.
Then, in their will, they split the rest of their estate equally among all the kids.
Okay.
Collation makes sure the kid who got the early gift doesn't inherit way more overall.
So it's like leveling the playing field.
It is.
So what kind of things do you have to account for in collation?
Article 1061 says any property or rights you got from the deceased person while they were alive,
Okay.
as a donation or any other free transfer, that's subject to collation.
So gifts, free transfers of assets, all that.
Right.
Are there any exceptions?
Yes. Article 1062 lists some.
Go ahead.
Collation doesn't apply if the person who gave the gift said it didn't have to be collated, or if you renounce your inheritance.
Okay.
And things you inherit through a will aren't subject to collation unless the will says so.
Okay, so there are some specific exceptions.
There are.
What about grandchildren inheriting through representation? Do they have to collate gifts their parents got?
That's Article 1064.
Okay.
The answer is yes, they do.
Okay.
It's about fairness across generations.
So those gifts wouldn't be ignored just because the parent passed away?
Exactly.
Okay, are there things that are never included in collation?
Yes. Article 167 says everyday support a parent gives a child isn't counted.
So food, clothing, education.
Those are parental duties, not gifts.
Okay.
And Article 1068 says money spent on a child's professional training or education isn't included either.
Okay.
unless it cuts into the legit time of other heirs or the parents explicitly said it should be.
So investing in a child's future isn't treated like an advance on their inheritance unless the parents specifically say so.
Right.
Okay. Are there any other rules we should know about collation?
Yes, when calculating collation, you use the value the property had at the time it was given,
Okay.
not what it's worth now.
Okay.
And improvements you make to the property after you get it.
Yeah.
Those can reduce how much is subject to collation.
Okay, so there's a lot of detail involved.
There is, yeah.
Okay, this has been incredibly helpful.
I'm glad.
Let's talk about the last stage.
Yeah.
Partition.
Okay.
What happens there?
Partition is when you actually divide the estate among the heirs,
Okay.
based on the will or the rules of intestate succession if there's no will.
So this is how the whole process wraps up.
It is.
Okay, so what are some of the general principles that guide partition?
Article 1078 highlights a key principle.
Okay.
Before partition, the entire estate is owned by all the heirs together,
Okay.
after any debts are settled, of course.
Okay.
And Article 1079 says there are two ways to divide things.
Okay.
You could divide the assets themselves,
Okay.
or you can divide their value.
So you can either split the pie into pieces or sell it and split the money.
That's a good way to put it.
Okay, what happens? What happens if the deceased person already said in their will how they want the estate divided?
Article 1080 says those instructions are usually followed, as long as they don't violate anyone's legit time.
Okay, so you respect their wishes, but within the law.
Exactly.
Okay, can someone other than the heirs be in charge of this partition process?
Yes.
Okay.
Article 1081 says the deceased person can appoint a mandatory to do it,
Okay.
either in the will or in a separate document.
So it's like delegating.
Yeah, delegating the task.
Okay.
The mandatory can't be an heir, and the heirs can challenge their decisions.
Okay, so there are checks and balances.
Definitely.
What if the heirs they can't agree on how to divide things?
If they can't agree, they can go to court.
Okay.
The court will decide, and that decision is final.
Okay, so there's a system for resolving disagreements.
There is.
Okay, are there rules about when partition can happen?
Yes.
Okay.
Article 1082 says an heir can ask for partition anytime,
Okay.
but there are exceptions.
Acceptance.
The deceased person can say in the will that the estate should stay undivided
Okay.
for a certain time, up to 20 years,
Okay.
or the heirs can all agree to keep it undivided.
Okay, so there's some flexibility.
There is.
What are some things to consider when you're actually dividing the property?
Article 1085 has a few key points.
Okay.
The division should be as fair as possible,
Okay.
both in the type, property, and its value.
Okay.
If there's property you can't divide, like a house,
Yeah.
one heir can get it and pay the others their share.
Okay.
If they can't agree on who gets it,
Yeah.
you sell it.
Okay, so there are solutions for those tricky situations.
There are.
What if one of the heirs sells their part of the inheritance before everything's finalized?
Article 1088 has a concept called legal redemption.
Okay.
The other heirs have the right to buy that share back.
From the buyer.
Yes, it keeps it from going to someone outside the family.
Okay, so it's about keeping it within the family.
It is.
Okay, what has to happen for that to be used?
The sale has to be to a non-heir.
Okay.
The other heirs have to be told about it.
Okay.
At least one of them has to say they want to buy it back. And it all has to happen before the final partition.
So there's a window of opportunity.
There is.
Cool. What about the quality of the property? Do the heirs have any protection if something's wrong with it?
They do.
Oh, okay.
Article 1092 says each heir guarantees the title and quality of the property they get.
Okay.
So if issues come up later, they're responsible.
So it's not just take it and forget about it.
No, they're responsibilities.
How long do they have to make those kinds of claims?
They have 10 years from when they find out about the problem.
Okay.
That's Article 1094.
So a 10-year statute of limitations.
Right.
What if an heir gets a debt as part of their inheritance?
Article 1095 explains that
Okay.
if they get a debt owed to the estate, the other heirs aren't responsible anymore.
Okay.
But if they can't collect on that debt,
Yeah.
they can't ask for more from the estate.
So it's like they take on that risk?
Yeah, the risk is theirs.
Okay, this whole deep dive into wills and inheritance in the Philippines, it's been amazing. We've covered so much.
We have.
From what a will even is to all the details about how estates are partitioned.
It's a complex system,
It is.
but it's there to protect families, distribute assets fairly, and make sure the deceased's wishes are followed.
It's been really helpful to break it all down.
I'm glad.
especially for anyone thinking about planning their own estate or maybe dealing with an inheritance here.
It's essential information.
I feel like I have a much better understanding of all these concepts now.
I'm happy to hear that.
It's been great.
It has.
You know, as we were going through all these details, it really made me think about the bigger picture, too.
Oh, yeah.
Like, how do these laws, especially the emphasis on legit time and reservatron call,
Right.
how do they shape family dynamics or even the distribution of wealth here in the Philippines?
That's a great point.
Yeah.
Legit time, for example, it provides security for spouses and children.
Knowing they'll get their share.
Exactly.
But it also limits how much freedom the person making the will has.
It does. There's a balance there.
Yeah.
And that potential for conflict definitely exists.
That's true. And reservatron call, while it aims to preserve family property, it could also lead to complications if people interpret it differently.
Absolutely. It can be tricky.
Yeah, it's also interesting to think about how these Philippine laws compare to other countries
Right.
where individual choice might have a bigger role.
Or where different cultural values come into play.
This deep dive has definitely opened my eyes to a lot of these broader questions, legal and societal.
It's not just about the law itself.
Yeah, exactly.
It's about how it interacts with real life.
It's a good reminder that laws are a framework, but human relationships and individual circumstances add all these extra layers.
They do. You can't ignore the human element.
Well said. This has been a really incredible learning experience. What are your final thoughts for our listeners as we wrap things up?
If you're planning your own estate,
Mm-hmm.
I would say get legal advice.
Okay.
Make sure your will says what you want and that it follows all the rules. And if you're dealing with inheritance right now,
Yeah.
remember that communication is key.
Yeah.
Understanding everyone's perspective can really help prevent or solve those conflicts.
Those are great reminders.
I hope so.
Well, a huge thank you to our expert for this amazing deep dive
My pleasure.
into wills and succession here in the Philippines.
That's been fun.
And to you, our listeners, thank you for joining us. We hope you feel more informed and confident about this topic.
Exactly.
It's complex, but it's so important.
It is.
Until next time.
See you then.